Hello, Justice Goodwine.
Hello.
Thank you so much for being a part of our Centennial Oral History celebration. I'm just going to start right in. What initially drew you to the legal profession?
Well, that started when I was about 16, and I was interested in becoming a judge. Justice Thurgood Marshall had been appointed to the U.S. Supreme Court, making history as the first African American to do so. And I talked to my parents, and I thought, that's something that I think I want to do. As part of a high school project, I went to our local courthouse to talk to and interview potential, possibly judges and others in the legal profession. And I was stunned that there was no one there that looked like me.
Wow.
And after that interview, because they seemed a bit bothered, there were no women and no African Americans, and the males seemed a bit bothered by the fact that I was even inquiring about judges and lawyers in the legal profession. And so I returned home and I said this was my experience. And of course, my parents always encouraged me to do and be whatever I wanted. And said, if you want to become a judge, then become a judge. And so that stuck with me. I remember early on reading Brown versus Board of Education, a case in which Justice Thurgood Marshall participated as a young lawyer, and was fascinated by the changes that came about as a result of that case and developed my interest.
Fantastic. When did you first begin practicing law, and then we can talk about when you first took the bench too?
Sure. So I was what they call a non-traditional student, even in law school. I moved to Lexington as a court stenographer. So I began in the legal profession as a court stenographer, sitting in the courtroom, recording everything that was happening. And little did I know how much at that time that would matter, and that would go with me. Knowing that I wanted to ultimately go to law school, practice law, and take the bench, being a court reporter certainly gave me that background. And so worked my way through undergrad as a court reporter, and went to law school a little bit later in life. It took me about 11 years to finish my undergraduate education. And so by the time I entered law school, I was a non-traditional student at 31. And a lot of people told me I was too old to go to law school at that time. They thought that perhaps I would have difficulty getting a job competing with the 20-somethings. And so when I graduated from law school, I thought I was going to prosecute. I thought that because of my mother's murder, that I wanted to get in there, put the bad guys away. And upon mentioning that to then Commonwealth Attorney Ray Larson, there were no openings at that time in 1994. So I thought, okay, well, what am I going to do now? And I had interned or did a summer clerkship with Wyatt Terry & Combs and contacted them. And was interviewed by Barbara Edelman, and she called me in, asked me what I wanted to do with my legal career. And of course, I gave the response. It was non-traditional and non-typical. It wasn't, I want to be a partner at this firm, but it was, I want to be a justice on the Kentucky Supreme Court. And so she looked at me like, we don't have one of those here. But if you want to come and work as an associate, then we'll be happy to have you. And so that launched my practice, my legal practice. And I worked at Wyatt for 5 years, did labor and employment litigation. Because I was older, that drew a lot more responsibility. The partners at Wyatt saw that I was mature enough to handle clients, able to travel and be able to conduct myself appropriately. And so it was given a lot more responsibility. Travel throughout the Southeast United States, Georgia, North Carolina, South Carolina, and Florida is where my clients were at that time. And so I did labor and employment litigation, human resource related matters, employment policy, drafting HR policy for various clients at that time. And then in 1999, there was a vacancy created on the district court bench. Now, I had told my partners when I started at Wyatt that, of course, my interest was to one day, absolutely. And they said, well, there's a political aspect to becoming a judge because both the appointment process and the election process involves politics. And so you're going to have to get in the trenches and learn the ropes. And there were former mayors that worked at Wyatt, a former governor worked at Wyatt, and they all kind of took me under their wing and said, okay, we're going to show you the political ropes. And,
fantastic.
Oh, absolutely fantastic. And so they introduced me to then Governor Patton, Paul Patton, and his personnel cabinet. And Governor Patton was making the appointment to fill that vacancy. And after several meetings with his office, I was notified that I got the appointment. And so in August of 1999, I was appointed to the district court bench, making history, becoming the first African-American female to serve in that role. Now, that was in August of 99. The election was in November. So I had a short turnaround time to learn the job I was doing and campaign and run for office.
Gosh.
And so we had 10 of us in that race.
Oh my gosh.
Yeah, there were 9 opponents, 10 including myself. And I won that election, began as a district court judge in 1999, jumped, straight in. And it was incredible because a few years after taking the bench, actually it was about 2 years, was 9/11.
Yes.
And so I was in felony criminal court. And I remember the prosecutor, Sally Manning, coming up to me saying, Judge, plane just hit the tower. We thought it was an accident. And, we had stopped for a moment and then realized that it was a terrorist attack. And so it was to be a new judge on the bench, to have that happen in court and to see that play out was so incredible. Yes.
What was the FCBA, the Fayette County legal community like when you were first starting out? I think we talked about it a little bit already, but also who were your early mentors and how did they influence your career?
So as you can imagine, because Barbara interviewed me, and in fact, I think she would be wonderful to do this project if she hasn't been contacted already. But Barbara Edelman was the exact same as she is today. Very matter of fact, very down to earth. And like I said, she told me, well, we don't have one of those here. We don't have those here. But if you want to come and work for us, then, fine. And I will never forget, she wasn't my assigned partner, but of course we could get work from anyone. They tried to match a partner with an incoming associate on the same floor. So Jennifer Madden, was right next to my office, and she was my actual assigned mentor. But Barbara gave me this project, and it was a massive research and writing project. And of course, it was like Friday at 3:15, and of course, it had to be filed on Monday morning. Of course, what other kind of projects were there, right? And so I took her. I was like, okay, no problem. I'll stay here all night. I'll work, all weekend. And work on it, and did that. And of course, first thing Monday morning at 8 a.m. and I put it on her desk, and she's looking at me like, what? And I was like, well, you said you needed this by Monday morning. And she's like, I did. I was like, yeah, you did. But she was just fantastic at, it's going to be okay. You're going to work hard. You have your dreams, you have your goals. And all of those things can work together. And she was very, very encouraging to all of the women in the firm. I was the first African-American female hired at the firm.
Wow.
And so I mentioned to her in conversation about why there hadn't been others. And the conversation was, we just haven't been able to recruit and retain. And I said, well, how about I take that role on the personnel committee and travel around to universities and try to help recruit, try to open the doors for others. And that's what I did. She allowed me to do that. So in being my mentor, she helped me to become a mentor for others.
Yes.
And then Judge Jim Keller,
Mm-hmm.
earlier, when I was a court reporter, he was one of the first judges that I was reporting for. And I shared my vision with him. And so along the way, I stayed in contact with Judge Keller,
Mm-hmm.
who, encouraged me along the way and said, okay, now here's the next step. Here's what you have to do, And when I felt like, oh my gosh, I don't know that I can do this, or oh my gosh, here's what's happening. And, he'd say, just, keep a cool head. You're going to be fine. Everything's going to be all right. And so those were words of advice from two of the best, I think, Barbara Edelman and Jim Keller, just help provide that base.
Yes. Are there FCBA moments, programs, or traditions that stand out to you?
I like everything about the Fayette County Bar, and in fact,
We really like you too.
I remember, and I think Dana Carter and I share their story about me being on the board when we were hiring an executive director for the Bar Association, and she was one of the applicants, and so I was interviewing Dana Carter.
Oh my gosh,
Dana Carter.
Yes,
yeah,
I know.
And I was. I mean, she's like, it was just so hard on me. Like I was like, I knew you had me. I knew when I saw you that you would be a perfect fit for the Bar Association. Yeah. So knowing that she was one of the first Fayette County Bar executive directors, and I helped bring her into that role, and then to see how the bar has grown since then, all of the programs from the CLEs to the social hours to promoting women with the Women Lawyers Caucus and Luncheon. All of those programs have been memorable for me. And of course, we've grown, obviously, from the Christmas parties of old and doing the different things that we do now to help promote others into the program. Yeah. I think have all been very phenomenal.
Great. Yay. Is there a case, a moment, or an experience that still stays with you?
Well, as you can imagine, being a trial judge as long as I was, there were many memorable moments. But the one I share is one in which, and I remember Herb West was the prosecutor. It was a capital case, and that we were trying. Everything about a capital case that you can imagine was going on in this case. So we had a juvenile in which the death penalty didn't apply. We had the adult. The juvenile was the shooter, and then we had the adult, and then we had this female lookout. And so when it came time, we had all of the evidence and the trial, and it came time for jury instructions. And so Herb West represented the female, and he asked me for a lesser included facilitation instruction to robbery. And I looked at him and I was like, why do you want to give the jury an out? Like, there's no way they're going to convict her of robbery, or, obviously she had nothing to do with the death, but even the robbery, because she's around the corner, they say she was a lookout. She said she just happened to be there. So he said, well, I think criminal facilitation would be good. And I was like, no, don't give him an out. So I talked him out of asking me for it. And when I read the jury instructions, my mouth dropped, because they convicted her of robbery first, which meant it's non-probatable, immediately remand, and it's there's no probation. Oh. And so I was like, this mother of like a small child, this was like on a Thursday night, she was going to have to go into custody right then, be gone for the weekend. I was like, oh my gosh, what have I done? What have we done? And so I called him up to the bench, and I told her, I said, file a motion for a new trial. I said, this is my fault. I should have given you your criminal facilitation instruction. I said, file a motion for a new trial. The comments up there, and I said, I'll grant you a new trial unless, Mr. Prosecutor, you will offer her criminal facilitation misdemeanor, 12 months. And so come Monday or Friday, they agreed, the prosecutor agreed that in lieu of a new trial, he would let her plead guilty to criminal facilitation. So they brought her back over on Friday. So she spent that night in jail, brought her back over on Friday. She pled guilty to that, and I was able to send her home. 2 years later, I saw her at the hair salon. I mean, we had the biggest hug.
Oh,
Because
yes.
she just hugged me and thanked me, and she said, I finished school and I'm doing well, and thank you. And she said, I learned now, to stay away from the wrong crowd.
Yes.
And I owe you for that. I thank you for that.
Oh.
And so I thought, had I not acknowledged the fact that he could have appealed, of course,
Right,
because he
right.
asked me for the criminal facilitation instruction and I didn't give it to him. So he could have appealed. I could have just stuck to my gut and just appeal it. But I knew what effect that was going to have on that young mother.
Yeah.
And so I admitted my mistake. I admitted that he asked for it and should have gotten it.
Right.
And the prosecutor agreed. And so it all worked out. And that has stuck with me. So through all the trials that I've had. And I said, and it taught me that no matter what you think, sometimes it's best to just listen to them.
Yeah.
And that being my experience, I tell attorneys too, I said, sometimes listen to what the judge says, because
it goes both ways.
It goes both ways. Instead of wanting to object all the time, you might want to listen to what I say. So in that case, it works in the lawyer's favor. There's been a few cases that, where it worked against the lawyer because he wouldn't listen to what I had to say. So, yeah.
Yes. Well, I love that. I love that story, and seeing her so much, down the line, like it really made a difference in her
and
life.
She appreciated that, and it set her on the straight and narrow path.
Right.
And she got her education. She was able to provide for her kids, and she was doing well.
Right.
She was doing
well. Which is exactly what we're all looking for anyway. Right. What changes in the profession have stood out to you most over your career?
One of the things that I've seen is the decline in civility. And it has been gut-wrenching.
Yeah.
I've been on the bench a long time, and when I first became a circuit judge, to see the conjugality and the professionalism on both sides, how the lawyers zealously advocate for their clients, shake hands, exchange discovery, you need an extension, okay, fine. You need an extension, okay, fine, and worked well together. Fast forward, 10 years, 15 years, and I'm seeing objections made just for the sake of objecting, criticisms of opposing counsel because they don't have the newest technology, setting up roadblocks and making things especially difficult, making my life much more difficult because I had to intervene with motions to compel, which aggravated me to the point where I got to the point that unless you can show me where you picked up the phone and tried to work this out, don't even schedule a motion to compel. And like I said, attorneys arguing for the sake of arguing.
Yeah.
I'm like, that's not making you a better lawyer. You can advocate zealously for your client and still do it in a professional manner.
Right.
And I have mentioned that when I talk to law students at law schools, and say to them that doesn't make you look like a better lawyer.
Right.
Right.
It is like almost like the TV or movie kind of affectation, like, like, yeah. You can leave
things that can be worked out should be worked out.
Yeah.
And that litigating and arguing for the sake of arguing doesn't make you a better lawyer.
Right.
So that is the one thing that I saw decline over the course of my years on the trial bench, that I hope that we can get back over time.
Right. I feel like COVID hurt it too.
COVID hurt it too.
It kept us all separate, and we're just kind of having a hard time getting back.
And I was on the Court of Appeals when COVID hit. So I didn't get to see how that impacted the trial practice as much because I had already moved to the appellate level, but I can see how that would happen.
Yeah. Like just kind of figuring out new ways of getting back to that camaraderie again. What advice would you give to young lawyers or future judges just starting out?
The advice that I would give to young lawyers is to seek out those mentors. I see a lot of young attorneys making the mistake of trying to wing it. Trying to wing it on their own, whether it's they don't know who to ask, or whether it's because they don't want to look bad.
Right.
I say, well, you look worse when you go into court and not know what you're doing.
Right.
Some judges will help new lawyers to some extent, but others will not. I would advise young lawyers to also know the judge they're going before and know the reputation of the judge. Get to know the judge's clerks and find out what that judge expects. I always tell new lawyers also, you can have no better friend than the clerk. So get to know those deputy clerks in the clerk's office when you go to file pleadings, or now everything's electronic. So, but get to know the clerk so you'll have someone that you can call when something goes wrong, or
you have a question.
You have a question.
Sometimes I just have silly questions about silly things.
And here, when attorneys come to Fayette County, of course, I tell them to go through Dana Carter. If you want to set up the courtroom or you want to see how the equipment works, make sure that you all do all of that beforehand. And the similar advice to young judges who, we have judicial colleges as continuing legal education or judicial education for judges for them to attend, but also they need to have mentors. Young judges don't know it all either, and some of them think they do. But we try to now assign judges to new judges.
Oh, that's great.
When there was a massive exodus in Jefferson County a few years ago, and I think half of the judges all retired. And so there was this influx of 10, 11, 14 new judges. And even in some of the other districts as well. And so what the Circuit Judges Association did was assign judges to each of those new incoming judges, just so that they could have someone to call.
Yeah.
And in fact, our very own Judge Minifield, Diane Minifield, was assigned Judge Sumi from Northern Kentucky as her mentor, who was excellent. So assigning a judge who had been on the bench for a while with a new judge that was incoming was invaluable, someone for them to call on. Here in Fayette County, when I took the bench, of course, there was 5 other judges that was on the bench. Judge Payne was here at that time. So we had our own built-in mentorship.
Right.
That was very, very beneficial.
Well, I'm like, I live in Winchester. There's, I think, 2 circuit judges. And then like 2 family court judges, and like that's
and
it can happen. Those changes can happen, like all of them at the same time. Yeah. Oh, that's fantastic. What values do you believe should never change in the legal profession?
Being prepared. Being prepared. An attorney should never go into court thinking they're going to win it. No matter how many times they've had that case, that motion, attorneys should always be prompt, should always be prepared, and should always be professional. Those are the 3 P's of practice, as I like to say.
That sounds like a t-shirt to me.
The 3 P's of practice. I was always prepared, always prompt, and always professional. And those who came into my courtroom knew that I will have read their brief. I knew what the issues were. I knew what the motion was that was pending before me. And so you need to be prepared for my questions. Okay?
Yes.
And that's something that I have, since day one, believed was very, very important. And I don't think that should ever change.
Yes. I'm sorry, I'm just writing. For when I make your t-shirt. As we celebrate 100 years of FCBA, what makes you most proud of this community?
Wow. The changes that I've seen in the community, I've seen this community grow. That has been the most fantastic thing to me. And to think that I've been in it 46 of those 100 years. And I came into this profession at 19 years old as a court reporter.
Wow.
I walked into the courthouse with my little steno machine. And this community embraced me even before I was part of the Bar Association, just being part of the community. And working within the legal community. I was that, as the judges said back then, I was that voice that I didn't have a side. And so I could be the voice of reason when either side had a question, or how did I do on voir dire, or how did I do on that question? You know, they would come ask the court reporter. You don't get that from video. And I told them when they were going video, I said, now there are some things that you can't replace with the video and audio recording. And I treasured those moments because the attorneys would talk to me. And they would even say, well, how do you think I came across with the jury? Or how do you think I handled that situation or that question? And a lot of them would say, you're actually taking down every single word. I said, yeah, every single word. And being a part of that community then, and seeing how it's grown, seeing how it has advanced with technology, and embracing that, because I went from the person actually doing the recording as a court stenographer to becoming a practitioner under the video audio component, and then becoming a judge who utilized that aspect of it, who also had to have depositions in my trials that were either played back or read back. So to see that come full circle, and to see that growth and that advancement in technology, I think has been a benefit to the community, and the community has absorbed that. So I want to see that grow. I want to see that continue. I want to see all of the law firms have access to the latest technology. Our challenge today is AI. And how getting the attorneys to understand that AI is not necessarily your friend, that you can certainly use it as a tool, but don't use it as a crutch. Because it will let you down. And like that case it cited to you doesn't exist. And if a judge happens to find out that you have cited and relied on a case that does not exist, you're going to be in a lot of trouble. So much trouble. So it's a good tool to use. ChatGPT is also a good tool to use. Just don't become dependent upon it. And I remember as an attorney starting out right out of law school, I was shepherdizing the long way, like looking it up in the book, getting the pocket part, making sure. You know, now you can push a button, making sure that when you shepherdize that case, when you use Westlaw or Lexis or whatever the program is that you're using, that you make sure that it's legit, and that you don't just simply rely on AI to write a brief or to write a response, because you don't want to get the judge's ire. You know,
I cannot imagine.
Because once that happens, it's very hard to overcome.
I would think.
When a judge realizes that you have
cut a corner.
The other thing that I tell young lawyers too is, even though you have electronic filing now, don't wait till 11:59 to file a pleading before a midnight deadline, because the Murphy's Law is going to come into effect. So it's going to freeze. The machine's going to cut off. The Wi-Fi is going to not work, and it's not going to get filed until 12:05, and then it's not going to be timely. So I had to write a dissent because that happened. And she pled she did everything. She waited till 11:59. First of all, she filed it in a case that was confidential, that doesn't take electronic filing. So she didn't check that. And then when she realized it didn't take electronic filing, she tried to file it in a sister case, which was the wrong case, and then tried to get the clerk to take it out of that wrong case and put it into the correct case. I wrote a dissent because a couple of my colleagues thought, well, it wasn't her fault. No, yes, it was. Yes,
Here's the rules.
Yes, it was. She waited till 11:59 to file it, okay? And she didn't know ahead of time that you can't file electronically in a confidential file prompt and
professional.
Exactly. Yes.
Absolutely. Is there anything that we didn't ask about that you would like to share?
So when I get that question, I like to share a couple of fun facts.
Yay.
One is that I'm a jazzercise fitness instructor because
Yes.
I believe it's important that we in the legal profession have an out.
Something that's not the books and not the practice. And
it is something that you can turn to relieve that daily stress. So for me, it was jazzercise, and it was jazzercise at 5:30 a.m. because I got my day started. I got that exercising out of the way. And then during COVID in 2020, I was offered an opportunity to be a ball girl for the WTA.
Oh.
The WTA came to Lexington for the Top Seed Tennis Open, which is a prelude to the US Open.
Yes.
In August of 2020. So I thought, what the heck? I'm going to go apply. So I went, surely they're not going to pick me. They picked me.
Like, put her down. Get her on this list.
They picked me. They didn't recognize my name or who I was. These were people that came in from all over the world with the WTA tour.
Yes.
And passed my COVID test. And I was assigned to the tennis matches of the various celebrities. Serena and Venus Williams were there. Sloane Stephens was there. I didn't get to do their matches, but I did. I was the ball girl for the championship match between Jennifer Brady. And so it was on TV, and I told my husband he had to watch. And
like,
yeah, and he said, and I was like, honey, what did I look like? He said, like a girl chasing balls. And I'm a sports fanatic. So at one point I got so enthralled into the match that the referee was like, there's a ball. Get the ball. Oh yeah, I'm here for a reason.
But did you see that, Rose? Did you see this thing?
It was phenomenal.
Oh
so
my
that's
God,
a fun fact
that's so exciting.
that not many people know. And once you work a game, so I'm listed as, I can go to the US Open, I can participate as a ball girl and at any WTA approved event. And of course and that was during COVID, so we had to wear masks.
Right.
It's like 100 degrees outside.
Oh yeah.
We're in black shorts. But it was just so amazing. And, we couldn't approach the athletes for photographs, but they told us, but if any of them want to take photos with you, then you're welcome to do that. So Sloane Stephens did. It was phenomenal.
Oh my God.
And another secret was that Serena Williams stayed in my neighborhood in Greenbrier. Of course, we didn't know she was there.
Right.
But we found out during the tournament that she was staying in Greenbrier.
Oh my God.
Isn't that cool? It was the coolest thing. I have pictures. I have pictures of me. I said, see, I really was a ball girl. And so my husband will show that video of me chasing the balls down. I did the back court. I didn't do the net court.
Oh yeah.
But I did the back court.
Oh my gosh.
And it's a technique. It really is it's a technique, but
yes, get out of the practice and get into something. Yes.
Absolutely.
Yes.
It's phenomenal. I love sharing that fun.
Well, thank you so much for all of your wonderful conversation today, Justice. Thank you so very much.
Thank you for having me.
Oh, you're so welcome.